But to just be able to unilaterally designate every single document they have that's not in the public record as attorney's eyes only is not really appropriate.
All right, on page 9, Mark Munger versus David Mahon.
Morning, Your Honor. Todd Prall on behalf of the third-party plaintiffs other than Full Color Games Inc.
Morning, Your Honor. Jeff Hulet on behalf of Full Color Games Inc.
Good morning, Your Honor. Stephen Caloiaro on behalf of the Bragg defendants. With my colleague.
Good morning, Your Honor. Brady, Bathke on behalf of Bragg defendants.
Good morning, Your Honor. Rory Kay of McDonald Corano on behalf of Spin Games, Kent Young, and Colonel Mishra.
Morning.
Morning.
All right, should I just call these in order, the order on which they're on the calendar?
Yes, Your Honor.
First one is third-party defendant's motion for protective order. And there's joinder. I believe there's joinder by Spin Games et al., right? To that motion.
Yeah, there is, Your Honor. Just to clarify, Lorraine's probably going to want to throw me off the roof. We filed a joinder to the reply, but we mislabeled the caption. So you'll probably see 2 joinders today.
Oh, okay,
but it's a joinder to the motion and then a joinder to the reply later.
Okay.
Third-party defendants bring this motion for the entry of a 2-tiered protective order to govern discovery throughout this matter between third-party plaintiffs and third-party defendants. Specifically, a 2-tiered protective order that allows the designation of sensitive and highly confidential business documents designated attorney's eyes only, without entry of this requested protective order to govern discovery. Disclosure of information between direct competitors, as third-party plaintiffs and third-party defendants are direct competitors, would cause actual competitive harm. In this matter so far, third-party defendants produce documents under the belief that the respective designations would be honored until a protective order was entered. Third-party defendants, in good faith, produce documents, and that should not be seen or taken as an indication that any motion for a protective order governing this litigation is untimely, and third-party plaintiffs offer no support for that contention.
I want to make sure I understand this, the 2 tiers. What's the first tier?
So it would just be, the first tier is just confidential documents, and then this 2-tier protective order would govern sensitive and highly confidential business documents, and those would be designated attorney's eyes only, compared to the single tier, which would not be attorney's eyes only.
Okay.
So far, third-party defendants produced 548 responsive documents and only marked 14 of those as highly confidential attorney's eyes only. And so third-party plaintiffs are opposing this motion for just those 14 documents. However, this motion is to govern all of discovery in this litigation. And parties have meet and conferred about this, and third-party plaintiffs' counsel only threatened to disclose all the documents that third-party defendants already produced to third-party plaintiffs. And courts routinely enter these protective orders granting confidential and highly confidential designations to protect trade secrets and sensitive commercial information from improper disclosures, which are at the matter here. Courts enter these protective orders to facilitate the parties' discovery exchanges without fear of improper disclosure. Third-party plaintiffs have provided no rationale why a 2-tier protective order should not be entered. They only argue that the 14 documents marked attorney's eyes only in the first set of document production are not worthy of attorney's eyes only designation. However, this is not what this motion is for. This motion is for a 2-tier protective order to govern all discovery. It's not based just on those 14 documents. And third-party plaintiffs and third-party defendants are direct competitors. Third-party plaintiffs have even stated multiple times several assertions in their motion for preliminary injunction and other assertions in several different replies. And multiple courts have granted the motion for protective order allowing attorney's eyes only designations for sensitive business documents such as these here, because it would shield a company from the undue burden and specific harm of providing that proprietary information to a competitor. So that's what this motion is here for, just to guard against improper disclosure of that information to the other parties. And third-party plaintiffs have repeatedly made material misrepresentations to third parties, and that not only constitutes good cause for entry of a two-tier protective order, but it creates a presumption of harm that would result from the absence of any two-tier protective order in this case. Third-party plaintiffs have established by their conduct, which was previously sanctioned by this court in the form of a gag order, that a protective order merely protecting against disclosure of confidential information is insufficient in this case. Instead, this court should enter the requested two-tier protective order to allow for attorney's eyes only designations to ensure that both parties' confidential, non-public information is absolutely protected from improper disclosure. And third-party plaintiffs will also not be prejudiced by entry of this protective order. As third-party plaintiffs oppose this order, they oppose this order on the basis that an extra level of protection above confidential is not warranted. However, they're the same party that told the court it would be irreparably harmed by the improper disclosure of proprietary information to a competitor. And also, the proposed protective order expressly provides a mechanism by which a party may challenge the designation of any material produced. So third-party plaintiffs are, in their motion, argued that the 14 documents out of nearly 550 documents that third-party defendants produced did not warrant attorney's eyes only protection. However, with the entry of this protective order, they have a mechanism for challenging those designations. And this mechanism is twofold. It maintains confidentiality of sensitive information and affords both parties to challenge any improper that they feel designations. And this process is commonplace. Third-party plaintiffs' refusal to stipulate in this process, they defy NRCP 1's directive that the rules of procedure should be construed, administered, and employed by the court, and parties to secure just and speedy determination of every action. Thank you, Your Honor.
Okay, thank you. Response?
Do you want to hear the joinder at all, or should I just go for it?
It's on, I can
Oh,
be
yeah.
really brief, Your Honor. When I was preparing for this hearing, I went back and looked at the Coyote Springs case from, I think, 12 and a half years ago. It was the first time I ever appeared in front of you. That case had a protective order, much like this one. We fought about everything in that case, as you may recall, but we didn't fight about an attorney's eyes only designation.
And now there is a fight.
Yeah, exactly. Well, and I will say, in the intervening 13 years I've practiced in front of you, this is the first time I've ever had a fight about an AEO designation. We used it as recently as the Formula One Liberty Meeting case in front of you. I've never had anyone, at least as to the entry of protective order, argue about whether it should have an AEO designation. We can have the fight once we produce documents and Mr. Hulet and Mr. Prall review them as to whether that designation is appropriate. This protective order allows them to do that. And I've had that fight before, but I've never had anyone as a threshold matter say they won't agree to a two-tiered protective order. And I will say, and I will just highlight here, the original protective order that was entered in this case 4 some odd years ago doesn't cover our clients, and so we're not parties to it. And so we do need, at least some form of protective order to bind all of the folks at this table, and of course, the folks on the side. But as to the two-tiered nature of this, in the attorney's eyes only, I've never had anybody oppose it as a threshold.
Well, when it's not raised as an issue, then we're going to get into the substance of what it means.
Well,
When parties agree on it, okay, fine.
yeah, and they have a right under this, yeah, you're right, and they have a right under this protective order to challenge any AEO designation. If next month, and mind you, my clients haven't produced many documents, but we will be producing highly confidential documents. The whole case is about theft of trade secrets and very technical source code and all of these other things that are most appropriate under all of the cases cited for an AEO designation. If they think we've improperly designated something later, they can come back and challenge you and say that it isn't appropriate. And then, of course, you can order disclosure at that point in time. But as a threshold matter, I don't think there really is any reasonable objection to this protective order or the two-tiered nature of it for AEO designation.
How do you see that an attorney's eyes only order works? How does the lawyer consult with his client about a document that the lawyer has but can't show it to the client?
Yeah, and I guess there's 2 points to that. With respect to this specific document, if opposing counsel or we believe somehow that the AEO designation isn't appropriate, the first thing we do is we come to you make the argument to you in camera, and you can say it's not appropriate. You can share it with your clients, at which point in time we would share it with the clients. As to a certain category of documents, in cases where we do have direct competitors, courts all over have held that it's appropriate to protect those, because what we've called our special sauce, as soon as we disclose that, Mr. Mahon and full-color entities, if Mr. Prall and Mr. Hulet share that with him, he can reverse engineer exactly what we've done, our most valuable asset, and that's why AEO designations exist. So you're correct in the sense that for a very small category of documents, attorneys on the other side can't disclose them to their clients because the clients are in the posture of direct competitors. And it would be, in essence, opening the door to all of our trade secrets to produce that sort of stuff. And that's not uncommon in these types of cases.
So the agent can see it, but the principal can't.
Yeah, and the reason why, again, is because the agent technically isn't a competitor of any of our clients, but the principal would be, and so that's why, I mean, you see these all the time out in Northern California where you have Silicon Valley companies battling out about trade secrets. We're in a different venue here, but the principles are the same, and that's why I think Bragg is cited appropriately in the cases that allow for this to happen.
Okay, thank you. Mr. Prall?
Your Honor, I think there's a little bit of confusion here about what this is actually about. This came about because of the designation of the 14 documents as attorney's eyes only when there was no protective order that allowed them to unilaterally do that. I would like to point out first that the protective order in place in this case does allow for attorney's eyes only if the parties stipulate and agree. What I do not usually agree to, and I don't agree to it, is allowing people to unilaterally designate attorney's eyes only without the parties either coming to the court for it or agreeing on it.
Well, there have apparently been 14 items that have been designated as attorney's eyes only.
And there's no order allowing them to do that unilaterally. And I agreed that I would not show it to my client
But
until
there
we
is
had
a
this
attorney's
issue.
eyes only provision in the existing protective order. Right?
There's no attorney's
But
eyes only provision that allows a party to designate it unilaterally without a new stipulation allowing for that protection. There is a provision in the order in place that if the parties agree and stipulate, they can do attorney's eyes only provisions, but not unilaterally designate it without getting the court's approval first.
Okay.
Is that fair? Does that make sense?
All right.
So, and I don't agree to these unless.
So apparently, then, it appears that the motion seeks to amend the protective order to provide for a different format.
Well, yes.
Right?
This is what I'd say. Technically, they are correct that we have asked them to agree to the protective order in place. They came into the case after this protective order was entered. They have never formally said we'd agree to it, but we have produced stuff to them under the protective order from our side that requesting it remain confidential, not attorney's eyes only, but just general confidentiality. And so, technically, should we have a new order that governs everybody? Yes. What our proposal is that the order in place should be that order, and we don't need, we should not have a two-tiered, it allows for two-tier if the parties agree, but it doesn't allow either party to unilaterally designate attorney's eyes only protection without obtaining it from the court. That's what we're fine with. We're fine with that, and to say that the way that they designated these 14 documents shows why we are not wanting to agree to allow them to just unilaterally designate things as confidential, attorney's eyes only. And they're exactly right. It makes it more difficult for me as counsel to represent my client when I can't show them documents. And if there are attorney eyes only protection that might be viable for commercial reasons, it should be extremely narrow for only the documents absolutely necessary for. And that's why my proposal is that we have, if there's attorney's eyes only, we need to agree on it or come to you first, not just be able to unilaterally put attorney's eyes only protection.
So the concept of attorney's eyes only can go forward. It's just that the manner in which it's effectuated, there's a disagreement on that.
There's a disagreement on that and the manner that it would happen. That is correct, Your Honor. We're not opposed to confidentiality orders in this case. In fact, again, there is a brief reference to attorney's eyes only in the protective order in place now. But it doesn't allow either party to designate unilaterally, hey, we just want this protection. So that's where we are coming from. And the documents that they have designated, here's the problem I see. The documents they produced are either completely public record, literally they are in the public record, or they've been designated attorney's eyes only. There's no in between. So they've basically said either everyone can see it, it's in the public record, or it's absolutely protected and no one can, and I can't even give it to my client. And that is not really an appropriate way to use attorney's eyes only provisions. The documents in the attorney's eyes only stuff, it includes the core documents of their agreements that to buy Oryx that is at the center of this dispute. And they're basic documents like the shareholder agreements. There's nothing super confidential about a lot of those documents, yet they only appear in their attorney's eyes only documents. I'm okay with them being confidential if they're not in the public record, and we can agree on that. But to just be able to unilaterally designate every single document they have that's not in the public record as attorney's eyes only is not really appropriate.
I'm understanding, don't you say that there are jillions of documents that have been presented, but only 14 have been designated attorney's eyes.
Right, but all the jillions of documents, other documents, are public record documents. Documents my client probably could have gotten on his own anyway. They are literally public disclosures documents, documents where, Bragg is a public company, they do press releases. Those types are the ones that didn't have a designation. Anything that wasn't literally in the public record, public designations, press releases, all that kind of stuff, was designated attorney's eyes only. So to say, oh, they only did 14 documents, well, they did everything other than the things that were already in the public record. And so to say that that's an appropriate use of that is completely ridiculous. It's not an appropriate use of it, and that's exactly why we don't want them to be able to unilaterally do this. I would acknowledge there are documents that we probably have to have attorney's eyes only in this case, and especially more related to spin than the others. That's really, and so I would acknowledge that that's going to probably be appropriate for certain types of documents, but maybe not nearly as many as they can intend. I would note a couple of other things that my client has maintained confidentiality of any documents provided to him, and I think they've done the same. He has never disclosed documents that were disclosed in discovery confidentiality. All this other stuff they say wrongdoing, board sanctions had nothing to do with that. And so if they just need to be confidential, they're going to remain confidential. If he uses them inappropriately and doesn't keep them confidential, they don't need an attorney's eyes only provision to enforce that. They just need a confidentiality agreement. And that's what we're completely willing to do. And so we just don't think that, first of all, these specific 14 documents are entitled to attorney's eyes only. We don't see anything in them that is trade secret or anything like that. We don't think they should be able to unilaterally designate that. We think there may be circumstances where we can reach an agreement on whether they're attorney's eyes only, and if not, we can come to the court. But what we don't want is them being able to unilaterally use it the way they've already shown they're not really using it properly. And so that's really what our position comes down to, Your Honor. They're thinking that they can use this as a way to punish my client for other irrelevant things to this discovery. And on top of that, I mean, literally one of their documents that they designated, it's identified as a single document, is 1,000 pages of all the documents in a packet for the entire transaction that is at the center of this dispute. And to just designate that all as attorney's eyes only, I think was not proper anyway. And so to say, oh, there's only 14 documents, I mean,
Okay,
the
so
point is all they designated is anything that was not already basically in the public.
you have no problem with the notion that there should be an all-encompassing protective order, right?
Yeah.
Now that, as Mr. Kays has indicated, there are parties now that weren't in at the time the original protective order was issued, right?
Correct. We have a protective order that we've asked them just to adopt.
And just make
They
it
haven't agreed to it.
encompassing to all parties.
Right.
You have no problem with that. It's
No.
just that your contention is that any attorney's eyes only provision should have a procedure that is different from what's proposed by.
Yes, that's correct. And to the extent that they are seeking, and I thought they were seeking to have these specific documents put as attorney's eyes only as a protective order. And if they're not, they're just trying to get a procedure in place. We don't think those should be, and we would have to actually, I guess, fight about that more if it's not part of the motion here today. But and we don't think that they should be able to, under the circumstances of this case, we don't think they should be able to unilaterally designate attorney's eyes only documents.
All right, thank you. Response?
Your Honor, this is to motion to an entry for protective order. It's not amending any protective order. We third-party defendants were not a party to any protective order prior to entering this case, and we would never agree to that single-tier protective order that's already in place for the other parties. We are here for a two-tier protective order because it's attorney's eyes only.
But you're not subject to the prior protective order, is what you're saying?
Correct. And one of the points that counsel for third-party plaintiffs made is that, again, these 14 documents that he mentioned, one document was not, didn't warrant a two-tier protective order. However, there's a mechanism in this that he can use, go to the court, and actually the two-tier protective order will be easier for the court to govern in this case, as there is that mechanism, whereas single-tier protective order, there would be a lot more disputes about whether things can be marked as confidential throughout that. Thank you, Your Honor. Mr.
Okay.
Yeah, Your Honor, if I may, I know Mr. Prall and the court referenced the original protective order. I have it pulled up. I know the court likes to look at documents and the specific language used. This protective order was entered on February 14th of 2019. There's a single reference to the procedure to handle attorney's eyes only documents. And Mr. Prall was correct that it reads, and this is a direct quote, that officers, directors, and employees of the parties may receive any document produced unless the parties agree that a particular document or material produced is for attorney's eyes only and is so designated. So in other words, the parties have to agree first that something's AEO before it can be marked. But how do you possibly do that when he would have to challenge our designation of an attorney's eyes only document? He would have to show the document to his client, which in and of itself defeats the whole purpose of an attorney's eyes only provision. That's exactly why I'm certain 99% of the two-tiered protective orders that come before you are exactly like the ones that Bragg drafted, where the attorneys themselves look at the document first. If they have issues with an AEO designation, then they would bring it to you on a motion to compel, not a threshold motion, opposition to a motion for protective order. Because my concern here is, as Mr. Prall said, if Mr. Mahon doesn't keep the documents confidential, there's no harm, no foul, but there is extreme harm. It's irreparable harm. Once a trade secret goes out into the public atmosphere, it loses its protection as a trade secret. So could we potentially sue Mr. Mahon or the full color entities for, violation of the Defend Trade Secrets Act or violating your order? Yes, but that secret sauce would lose its protection, not only from an informational standpoint, but everyone would know it, and so it's in the public record and it's no longer a protectable trade secret. And that's why we think the appropriate approach is the one in Bragg's proposed protective order, not the one in the prior protective order from February of 2000.
Just a general question here. How does an attorney's eyes only order work in terms of the lawyer consulting with the client? Is an attorney's mouth only too? I mean, can the attorney sit across the table from the client with the document and read things from it to the client and consulting with the client?
So, and that's a great question. In the cases that Bragg has cited, generally what happens is the subject matter can be discussed loosely. And we kind of revisited this issue once with the SEC investigation on all of those sorts of things. You can generally discuss a document. You can't discuss details until you come to the court, file a motion to compel, and ask Judge Denton to deem that this specific document, after an in-camera review, isn't an attorney's eyes only designation, at which point in time you're free at that point in time to share it with your client. And really, the types of trade secrets, and it's a very narrow showing for an attorney's eyes only designation. It's very easy for attorneys themselves, without consulting with their client, to identify whether they think it is a trade secret. NRS has an entire chapter dedicated to that. You evaluate the document, and if you think you need to be able to share it with your client because it's not a trade secret, we come back to you.
All right, here's what I'll do. I think the only issue regarding the protective order that's in place now is the attorney's eye only aspect of it, which the moving parties are seeking to, in effect, change to have a different kind of format. Right, so I'm going to grant the motion for protective order that will be all-encompassing, okay, for all of the parties. And I'm going to ask council to submit proposed competing orders on my ruling, okay? So the motion for protective order that's being sought now by parties who aren't the subject of the prior protective order, right, is granted, okay? But I want to review proposed competing protective orders. The elements of the existing protective order will remain in place. I mean, I'm not modifying any of those. What we're really looking at is the attorney's eyes only provision, right? So I want competing orders proposed. I'll review them and process one or the other.
I guess a question for you, Your Honor. Do you want complete orders that would be basically replace
I guess
order
you
that's in
could- I guess
place,
you-
or just an attorney's eyes only proposal?
I guess you could incorporate the prior order by reference or whatever. I mean, I don't.
Or should we just? I mean, I have no problem submitting a new order that either looks similar to the old one with maybe a few changes, and they can submit the one they like, if that makes sense. I just want to know.
In other words,
what
this could
makes
be,
more sense.
in other words, an amendment to the existing.
Or just an order that would replace the old one.
Your Honor, I don't want to misrepresent, but I think all of the parties that signed the previous order are no longer in the case. So, except for the third party plaintiffs, right? It was with the original plaintiffs who've since settled out. I don't know if some of the other third party defendants were
I
part
think
of
we
it.
need a new protective order now that will be all encompassing, and I want to see the proposed competing orders so that I'll be looking in particular at the attorney's eyes only provision.
Yes,
Okay?
sir.
And that's I actually think that's better to have a new one.
Yeah.
It's just
Okay.
it's just putting
Cleaner.
it together. So
Any more word about a settlement conference? All right, thank you. Well, I have the next motion. Yeah, I have another motion here, which is the third-party defendants, Matev's, Marigi, Adam Arvine's motion to quash service and motion to dismiss under NRCP 4, correct?
Yes, Your Honor. Good morning. I'll try to be pretty quick here. Your Honor, there was two defendants that were not properly served who kind of been before this court previously on these various motions to quash or service by publication. The court has issued several orders in the past. In the first instance, third-party plaintiffs came back to this court saying, we can't serve them through the typical means of service, where we should be entitled to do it by publication. The court granted it. In that instance, they specifically identified the types of publication they'd make and a date on which they do it. If you remember, we were at a status conference. The court said, I'm going to give you an extension to make service, but I'm not going to give you any more extensions. And that date, I believe, was in August, when that was the last day to serve parties. They then subsequently came back to this court and filed yet another motion to extend time for service. And because they deemed some methods that they previously agreed upon to serve being too expensive, they came back to this court and said, I know we told you we were going to serve this way, and this is the order we asked you to enter, but we really don't want you to do that. We really don't want to do that. So please enter this order. And so the court then entered a second order, which further extended the timeout to September 2nd and said, I'm going to allow you to serve the publication, but I'm doing it without prejudice that if this publication is not proper and it's not under the NRS's, defendants can come back and move to quash the service. And so that's what we're here for today, Your Honor, because service was not proper. So with respect to Adam Arvive, they served via the Miami Herald, a publication in the Miami Herald, and via a publication of a Canadian website. With respect to the Miami Herald, they've admitted that at no point were they aware that Adam Arvive was ever in Miami. And obviously under the NRS's, they have the burden to show that the publication was reasonably calculated to lead to notice, right? So their burden is to show the court, this is why we did it here, and this is why we believe it would be relevant, right? So for instance, if our clients were in Clark County, they serve via the Las Vegas Review-Journal so that they know we're in the Las Vegas Sun, and they say, listen, they're Clark County residents, these are the two periodicals in Clark County, this is the most likely to lead to reasonable service. So first, he was never in Miami. That was their own testament, is that they couldn't serve him because his house in Miami was empty and they never went there. So obviously the service in the Miami Herald was inappropriate and was not likely to lead to reasonably calculated to lead to notice.
Do you still own the house there?
I don't know. I really don't, Your Honor. But more importantly, they don't dispute this, right? There's nothing that says this is why we served in Miami and this is why it's proper. The second was they originally said that they were going to serve via the Toronto Globe. There was evidence that he was in Toronto at, I believe, I don't want to misquote Mr. Prall, but he was in Toronto at a private residence wherein he was on a certain floor of, I think, a hotel tower, and they couldn't get up to his floor, so they couldn't properly serve him. So they knew he was in Toronto, and they told the court, let us serve via the Toronto newspapers. In the first instance, the court said, sounds good, serve via the Toronto newspapers. They came back to this court and said, oh, we don't want to serve via the Toronto newspapers because it's too expensive. So they then picked this random Toronto digital website and said, listen, this is good. And it's not Toronto. They picked this Canadian legal notice website and said, here we go, this is good. This is insufficient under the Liberty Media case we cited. In that instance, the party was located in Reno. The third party, or the plaintiff in that case, tried to serve via a Las Vegas website. And the court said, listen, that party's in Reno. This appears to be a Las Vegas website. You can't just say it's good for the entirety of Nevada and say, there you go, we've served. You would need to serve through a Reno-specific periodical digital website. So same issue here, right? They serve through a general Canadian legal notices website, nothing specific to Toronto, where there's at least a belief that he is still at. And therefore it's inappropriate, insufficient. It's also not analogous to the third-party cases cited by the plaintiff. In those cases, the plaintiffs would create specific third-party websites so that the defendant would have awareness of, when you Google their name, it'd pop up, we're suing, legal notice to XYZ, and they would have better evidence. The second issue is that it is untimely under Rule 4.4, which requires that service is complete 4 weeks from the date of publication. This is not a hyper-technical rule as the third-party plaintiffs contend. 4 weeks from August 8th, when the first periodical went, was September 5th. The extended deadline was September 2nd. Service wasn't complete till 3 days after the deadline. The rule is the rule, and the rule is the rule for a reason. There was no compliance with it. And again, I'd just like to remind the court that when we met for the status conference that I flew down for, and the court ended up continuing it because parties weren't served, he said, August 19th is the absolute drop-dead date for service. The court then was gracious enough to extend it for the plaintiff's counsel to September 2nd, and then they still didn't get it done, right? To remind the court, November is the 5-year deadline, and we're still fighting about service on a party that was served, or originally included in this case about 2 years ago. All those arguments detailed to Adam Arav. With respect to Matt's, they originally came to you and said, let us publish in Clark County, and we're not sure why, because he doesn't live in Clark County. It's admitted that he lives in Slovenia. He's a Slovenian resident. And they said, also, let us publish in a newspaper in Slovenia. They then came back to the court after this August thing and said, oh, no, we don't want to publish in Slovenia because it's too expensive. So we just want to publish in Clark County. He doesn't live in Clark County. There's no dispute that he does not live here or reside here. They, again, have not disputed that and have not met their burden of showing how service in Clark County is reasonably likely or calculated to lead to notice of a Slovenian resident who does not reside in Clark County. That's the end of the inquiry, Your Honor. They spend a lot of time talking about actual notice, as this court has ruled in Phillips v. State Bar of Nevada, quoting Ninth Circuit precedent. Actual notice is not sufficient. The fact that I know that they've been sued and that they're trying to serve is not sufficient notice. That argument would essentially gut the entirety of Rule 4. So that is our arguments. I'm happy to answer any questions on this, but this should be a fairly perfunctory, straightforward matter, Your Honor.
All right, thank you.
Thank you.
Your Honor, I think that the thing we need to start with here is they've made several misrepresentations to the court about how this occurred. And the most important one is this. They never dispute that we made several attempts to serve these people in different ways, and they were just never around anywhere. They were impossible to serve. And a good example is Mr. Maziz. There is, in Canada, he made a disclosure for purposes in Canada that his residence was in Slovenia, and it gave an address. And we presented documents to this court where we attempt to serve him there, and the process server says there's nobody living there. There's no one living there. It's not an address where anyone lives. So we had no address in the world where we knew Maziz was, other than that he has some acceptance of service in Canada, which we did serve it there, and we had him published here. And again, and the court adopted that and agreed that would be sufficient without prejudice. But and the other point to make note of is we did not specifically request just for service via publication under 4.4. We requested alternate service because the service for publication didn't really directly apply, as the other side argued several times in previous motions, to these people who are international. We requested alternate service with specific requirements that the court granted and that we met. And so to say that full point 4 is the only thing that really applies and it's absolutely has to apply a certain way is not really accurate, because publication was part of an alternate service. We weren't just seeking for traditional publication under that rule. And so that's another reason that it's important to note that. But I mean, the most important thing, Your Honor, here is we presented in previous motions multiple times the history of our efforts to serve these people where they actually are, and we could not get them served there. He does have a house in Miami. We attempted service there. We never told them that he never lived there. We don't know that, but he was not living there. He probably has more than one house. He probably lives there part of the year. I don't know, but just when we tried to serve him, he was not there. And so that
Was, in addition to publication, was there mailing
yes, there was mailing both
to the house in Florida?
both house in Florida and the house in and the location in Toronto, the location where we're
back?
pretty sure he lives. Say that again.
Did the mailings come back?
The one in Toronto, I know didn't. I couldn't tell you for sure what happened with the Miami one. I'd have to check that. But the Toronto one certainly didn't come back. And so, but we did do we did do mailings on them as well, which was required by the court's order. So to say that this is and so this mechanism was an alternative service under Rule 4, but not specifically just the traditional publication ruling. And so that's really what we were seeking service under. That's what the court approved, granted without prejudice. But so we believe it was calculated to give them notice, especially when you consider all aspects of what was done. They were mailed, they were published in certain places, and with Maziz, we had it served directly on his resident agent in Canada, not just mailed, but delivered there, as the court ordered us to do. And we also had it published here, as we really don't know where he lives. I mean, he represented he lived in Sylvania, but that address, there was nobody living there. So we really have no idea. And that's why we asked this court to allow us to do it this alternative ways. This would have been much simpler had they actually lived where they said they lived in their documents, or you were able to access them, but that wasn't possible, and that's why we asked for this additional relief. And so we believe that they cannot really show that any due process has been violated in this case, that they were served as you ordered, and that they are here and they can appear and they can deal with the case on the merits, either as to jurisdiction or any other issues that might come up in the future. So we don't think that they order granting a motion to quash is proper. Second, on the 3-day untimeliness issue, number one, that rule is specific for specific types of publication, and to say it absolutely applies to this case, I don't even know if it does for sure, because we asked for alternative service, not just pure normal publication under 4.4. And second of all, if it does, it was a miscalculation by all the parties. We had asked, we wanted to make sure we had enough time, and that's why we asked for September 2nd. It was an inadvertent error to not ask for September 5th. It's 3 days. It should not change the way we go forward with this case. And so we asked that either the court just deny the motion to quash and allow us to go forward, or if the court feels it's necessary, grant the 3 additional days, which the court has the power to do under these circumstances. We think that would be reasonable as well.
Make sure I understand your latter aspect there.
Well, he argued that it was not timely because under Rule 4.4, you go 4 weeks from the start of publication. And the publication in Canada started on a certain date. If you go the full time, it would have ended on September 5th instead of September 2nd. And we had thought that September 2nd would be long enough, and that's what we requested the extension for, and you granted that. And so there was just an inadvertent error in calculating how much time would be necessary.
You framed it in an alternative way. You said the court can either grant the motion to quash or...
Well, deny the motion to quash, because that Rule 4.4 it applies when you're seeking straight publication.
Right.
This is an alternate service that included publication, but wasn't just the strict normal publication procedure. And so we don't think it directly applies, and it really doesn't matter a lot. And we should just deny the motion to quash on that grounds because they were served. We met all the standards of our order, of the order that was allowed, and we think that service was met as the court allowed, and that service was designed the best we could to make sure that we were giving them the best chance to have notice. They do have notice, and we're here. The alternative is, if you are concerned about that timeliness aspect of the 3 days, we requested that as a counter motion that you could extend it 3 days just to make based on a good cause and a excusable neglect on missing the calculation deadlines as required by rule.
Okay, thank you.
There's a few points, Your Honor, I'd like to address. First, regarding Mr. Matz and the, quote, documents, I think it's important to remind the court that those documents were unrelated to this litigation. It was a securities filing by Mr. Matz, and again, an unrelated issue. The court had already ruled on this, saying that service was not sufficient because it didn't comply with British Columbia law or under the Hague. That's why they sought for alternative service. So that issue is a moot issue. I'm not sure why it's being brought up here. Notably, though, what was absent from any of Mr. Prall's argument or in the papers is why they did the methods they did and how those methods are reasonably calculated to lead to service. Not a single answer as to why they use this Canadian website, how this Canadian website would potentially inform a Toronto citizen. No instance as to why with Mr. Matz the only thing they did is in Clark County when he's a Slovenian resident. Again, this is a product, and I'm going to beat this to death. This is a product of them over-pleading this case. They're trying to bring in a Slovenian resident, and they don't want to follow the rules. NRCP 4.4, which is Method for Alternative Service, clearly states under 4.4, it's 4.4, the order for service by publication and alternative methods of notice, that they still must comply with the notice of publication, which requires that it's not complete until 4 weeks after service. The rules are the rules, and Mr. Prall has now said that, listen, we came really under some form of alternative service, but none of our alternative services really comply with the rule. But don't worry about that because they have notice because we're here, and therefore we should all be good, right? It's essentially ignore everything that's happened, ignore that we didn't follow the rules, ignore that we didn't meet the service requirement, ignore that we've published in papers that aren't reasonably likely to lead to service, right? If they had gone to Slovenia, we probably wouldn't be here. We're going to be here on a motion to dismiss for subject matter or personal jurisdiction, but we wouldn't be here on a motion to quash. But they didn't go do a publication in Slovenia where the gentleman lives. I haven't talked to him in months. Don't know if he's gotten notice. They said, well, they have notice. They don't know if they have notice. Again, they're trying to equate my notice with these individuals' notice. That's not accurate, and that's not. There's no evidence that these people have received actual notice. So, thank you, Your Honor.
Okay, thank you. I'll review it further. Mr. Mayor, we'll see if I can.
Thank you.
Thank you.